We are now live.
Thank you, James. Right, good morning, everyone. Thank you for coming to the Licensing Subcommittee hearing. This is a virtual Licensing Subcommittee meeting that's being conducted by members, officers and members of the public at various locations, communicating via Zoom. There is also the opportunity for the public and press to listen and view proceedings on our YouTube channel. Please note that the meeting is being live streamed and the recording will be available following the meeting on our YouTube channel. Before the meeting starts, I'd like to confirm that members and officers are in attendance and can hear and be heard. So we're just going to do a quick roll call to make sure everyone's here. So if you can just let me know when I call your name. So Councillor Elizabeth Dennis.
Yes.
Good morning. Councillor Daniel Allen.
Good morning.
Councillor Ian Albert.
Good morning.
And Councillor Raj Bakar.
Morning.
And officers in presence. Melanie, you here?
Confirm, I'm here.
Simal?
Confirmed.
I don't think Jasmine's logged on yet. I know she's trying to get on, so we'll go over to James Lockgrove.
Yes, thank you, Sinead.
Noranata?
Present.
And I don't think Steve Cobb's online at the moment either. Okay, we're expecting other persons. We have Paul Taylor. Seen you somewhere. Can you just confirm you're here, Paul, for me?
You're on mute,
Yes.
Mr. Taylor.
Okay, fine, but it's very slow. It doesn't come up straight away. Thank you.
Thank you for letting us know. Have we got Brian McHale? Not here yet. And lastly, Neil Burton, representing the present.
I'm here and I can hear you.
Thank you very much for that. Right, we'll move on to item 1 of our agenda, which is the election of a chair. Can I please request any nominations for chair for this meeting of the subcommittee from the councillors?
Yes. Can I nominate Councillor Albert?
Thank you, Councillor Dennis. Do I have a seconder at all?
Can I second Councillor Albert, please?
Thank you, Councillor Allen. We will therefore, Councillor Albert is elected as chair of this meeting, and I will now hand over to him.
Good morning, everyone. And could I then have nominations for the reserve member? And perhaps if I could nominate from the chair, Councillor Bakar. Is there a seconder for that?
Yeah, happy to second.
That's great. Thank you. Thank you, and thank you, Raj, Councillor Bakar, and you'll act as our reserve member for the subcommittee meeting. Item 2, hearing procedure. Can I please invite the committee clerk to outline the hearing preliminary, which is details on page 3 of the agenda.
Thank you, Chair. So the subcommittee will consist of 3 voting members with a 4th non-participating member listening to the hearing. In the event that a voting member loses connection, the hearing will adjourn until connection can be restored. If the adjournment exceeds 10 minutes, or it is apparent sooner that reconnection will not be possible, the 4th member will replace the absent member and become a voting member of the subcommittee. If a quorum of 3 members that have been present throughout the hearing is not possible, the hearing will be adjourned to a stated date. Applicant. In the event that the applicant loses connection, the hearing will adjourn until connection can be restored. If it becomes apparent that a reconnection will not be possible, the hearing will be adjourned to a stated date. Other persons. In the event that an other person that has indicated their wish to speak loses connection, the hearing will adjourn until connection can be restored. If it becomes apparent that reconnection will not be possible, the hearing will be adjourned to a stated date. If an other person that has indicated that will be not participating orally in the hearing loses connection, the chair may decide to continue with the hearing. Decisions. The subcommittee will undertake their deliberations in private and return to announce the determination on the live stream. However, they will not wait until all parties are connected. A copy of the decision will be forwarded to all parties electronically as soon as practical. Are there any questions before we start the meeting? Okay, I will now hand back to the chair.
Thanks, everyone. And now, could I please invite the legal advisor, Simon Paxi-Cato, to outline the matters for consideration at the meeting? Hand over to you.
Thank you, Chair. The subcommittee is concerned with an application today under Section 34, subsection 1 of the Licensing Act to vary a premises licence. The nature of the variation is an extension of the hours when Shez Burton may serve alcohol, provide late night refreshment and play recorded music in the garden area of the restaurant so as to match the hours in the main restaurant area. The subcommittee's powers under Section 35 of the 2003 Act are to either modify the conditions of the licence or to reject the whole or part of the application, having taken into account all relevant representations received about the likely effect of the grant on the promotion of the 4 licensing objectives, namely the prevention of crime and disorder, public safety, the prevention of public nuisance and the protection of children from harm. The subcommittee will note that the variation application was served on the police and other responsible authorities and that none of the responsible authorities have raised any concerns regarding the variation application. But there have been representations received by other third parties. Accordingly, under the Act, the subcommittee must have regard to any third party representations that are, in the opinion of this subcommittee, neither frivolous or vexatious. Thank you.
Thank you. Thanks for that. Are there any questions for the legal officer at this stage?
May I ask a question?
You can. Can I ask you a question?
Right. I realise this is a multi-purpose form quite commonly used, but as a native person that doesn't get involved in these things, I find reading the implications of late night licenses with regard to the 11 o'clock serving of food and addition of alcohol after 11 o'clock a bit confusing. Could somebody perhaps clarify that for me?
Yeah, would the legal officer or our legal advisor or the licensed officer happy to pick that up at this stage?
Thank you.
Mr. Taylor, sorry, can
Yes.
I ask you to just repeat your question because I'm not sure I fully understood the question you were asking us.
As you read through the process of the forms, there is an implication about serving alcohol and food around the 11 o'clock time. And if you serve food before 11 o'clock, you cannot serve the alcohol after 11 o'clock as an addition. I'm not quite sure, is that relevant to this midnight license thing? I find it a little bit confusing.
In terms of the representations and the procedure for this hearing, Mr. Taylor,
Yes.
your representations need to be focused on the licensing objectives, the 4 objectives which I have set out. So if you have representations about this variation and they go to one of the objectives, then you may put them forward. Anything which doesn't relate to the licensing objectives is not within the scope for this subcommittee to consider.
Okay, that doesn't answer the question, but I hear what you're saying.
My time to check, sorry, apologies. So in terms of, sorry.
Yes, no, Renata.
I'm not feeling very great today, so excuse me. In terms of England and Wales, most establishments don't need a license for anything up to 11 o'clock. Anything after 11 o'clock is when you need your license, which is why they make the license application, and that's the difference. So by law, you can buy and consume alcohol up until 11 p.m. Anything after that is where the application comes in. Before that, we don't actually need a license. That is permitted by law. Does that assist?
Good, thank you. I can't see any other questions. If then I could ask the licensing officer to present any additions or amendments to the reports. Melanie.
Okay, good morning, Chair. There are no amendments to the published report. However, I do have a number of comments relevant to today's hearing. You will have seen from the report that some representations have sections that have been redacted. The summary of the reasoning for the main redaction is included in the report at paragraphs 8.7 to 8.13. May I remind all parties that any redacted information cannot be discussed at today's hearing, and any oral contributions from other persons must relate specifically to relevant areas of their representation or an expansion of those points. New information not included in the written representations cannot be introduced during the hearing. For example, if a representation deals solely with matters of public nuisance, the oral presentation cannot then cover other licensing objectives such as prevention of crime and disorder. The licensing process should determine how the use of the premises can be managed and what activities, if any, are appropriate in relation to the narrow consideration of the 4 licensing objectives. Excuse me. Any matters not relating to one of the licensing objectives are not relevant to today's hearing and must not be discussed or considered. The 2 licensing objectives raised in representations are the prevention of public nuisance. This relates to nuisance coming from or associated with the premises and can cover matters of noise, light, litter or odour. Examples are music or people noise coming from the premises or noise directly associated with the premises, such as vehicle, people noise outside the premises. Then the protection of children from harm. This relates to promoting safeguarding of children to ensure their welfare and protect them from harm. Preventing harm to children's health or development, ensuring children grow up with the provision of safe and effective care. As this application is to vary the premises licence with no evidence of previous issues associated with the proposed use of the outdoor area by the current applicant, the subcommittee should consider the impact or likely impact on the licensing objectives of the proposed activities and timings. Members should be aware that there would be the right to review the licence in respect of any issues relating to the 4 licensing objectives. Should you be minded to grant a licence today. Excuse me. However, if you believe the likelihood of an adverse impact on licensing objectives should be unreasonable to residents, you're entitled to reflect that in your decision today. The subcommittee is reminded that its determination today must be based on the specifics of this application and proposed management team. The subcommittee must assess the application, operating schedule and oral submissions of the applicant and assess whether it believes the applicant can adequately promote the licensing objectives. Whilst the subcommittee should have regard to the fact that the application has satisfied the responsible authorities, the subcommittee is entitled to make further amendments to timings, conditions if it deems appropriate to promote the licensing objectives based on the written and oral submissions. If the subcommittee is satisfied that there is no appropriate timings or conditions that will adequately promote the licensing objectives, it is entitled to refuse the application. I'm happy to answer specific questions now at any time during the hearing at your discretion, Chair.
Thank you. Thanks for that, Melanie. Do any of the other persons have any points of clarification at this stage for the licensing officer?
Yes, can I ask another question, please?
You can certainly, Mr. Taylor.
Right, on page 28 of the Annex 3, there are set conditions of which the licence is granted. And the first one is to do with the 10 o'clock closing. The second one is the premises licence holder will ensure that there is a separate unimpeded access to flat 1D that will not form part of the outdoor area used under the premises licence. If you look at the photograph or the drawing that's been presented, there is no actual separate unimpeded access to the flat. the access point from the rear of the garden is on the bottom right-hand side, and the flat steps are at the top of the picture. There is no visible sign of any separate access when you look at the property, and there's none shown here.
So could you, this is to ask for a question of the licensing officer. So I'm looking for a question here, Mr. Taylor.
The question is, why is there not a separate unimpeded access to flat 1D through the restaurant area as per the conditions attached?
Would the licensing officer like to come back on that question?
I'm just looking at the plan.
So on page 29, isn't it?
Yeah.
So on the bottom right-hand corner, you've got the access door.
Yeah.
And then you go up to the top.
I don't actually think, is this not relevant question actually to
Well, it is a relevant question because it's a condition that's been attached to the license, and it's not, in my view, it's not been adhered to.
Sorry, it's not relevant as it's not part of the application. Yeah. We could deal with that outside of this, but for the purpose of this hearing, it's not relevant.
I think if I just intervene there, Mr. Taylor, is that yes, I think that is a perfectly valid point, but that obviously is not one for today's hearing and does need to be picked up as a matter of enforcement separately. A perfectly valid point, but I think we obviously need obviously that is not part of the formal hearing and proceedings that we're looking at today. But I'm more than happy that we can pick that is a point that should be picked up outside this meeting.
I slightly beg to differ there because it does depend on the volume of the number of people that are in the garden area.
Look,
and therefore it reflects the number of people that will be dining there from 10 till 12 at night.
I understand what you're saying, but the advice I've received, that is something that we would need to pick up outside of this meeting.
And that's what for myself or somebody else?
Yes,
to
that would be
follow up with the licensing authority.
Yeah, that would
Mr.
be
Cole?
something to proceed with the licensing authority. Yeah, separately to this meeting.
But the fact that he's not complied with that condition initially, surely that has a bearing on the matter.
Well, that is something that is outside of this specific this hearing is purely about the operating hours. The gate. I entirely understand your point about the gate and access, but that is something that we would need to pick up separately. That is not for today's hearing. But I do understand the importance of the point you make. Totally understand that, but that isn't for today's hearing. But that is something that you have very happy that you should correspond with the licensing team after this, and no doubt, obviously, Mr. Burton's here today. I'm not asking him to come in on this point at this stage. It's because it's not relevant for this hearing. But obviously, he's obviously heard your question, and obviously something that he can reflect upon as well. Okay,
fine, thank you.
Okay, is there any? Does the applicant have any points of clarification for the licence officer? Mr. Burton.
Hi there, good morning all. Only a couple of things. Firstly, my name's spelled incorrectly on the application there. I can confirm, I've got 2 L's in my name, but I can confirm that I am the person that made the application. So if you can just make sure that
Thank you.
Changed in anything going forward. Also, there was another point of clarification. I was told that only other persons in the briefing pack were on this call, because I couldn't add anybody else to. I wanted my team to be on this call as well, but I couldn't add it. I don't see a representation from you, Paul, from Paul Taylor in my briefing pack. So just wanted to understand, am I still seeing the right briefing pack? And are there,
yes.
Under what status is
like to
representing?
Yeah, thank you, Mr. Burton. Melanie, would you just like to respond on that?
I'd just like to say that Mr. Taylor is actually representing 2 of the other persons, because they're unable to attend, committee was aware of that. He's representing Mr. and Mrs. Watts and
Mr. and Mrs. Taylor.
Taylor. Yeah, sorry,
Thank you.
name just went there. So
Okay,
that's
that's
why
fine.
it's here.
But I'm assuming that there won't be any other conditions that I need to prepare for other than the ones that were documented in the briefing pack. Is that
Correct. He was informed that he can only comment on their behalf on their representations, unless he had a personal experience of their representation.
okay? So nothing about unencumbered access to different flats.
No.
Correct. Okay, that's all my questions. Thank you.
Thank you. Do any members have any clarifications for the licensing officer? Can't see anything. If not, thank you, colleagues. Which then I think takes us forward to applicant representations. Could I invite the applicant, Neil Burton, to present your submission supporting your application? Mr. Burton.
Of course, thank you. And thanks for this opportunity, by the way. There's a couple of things that I probably want to do, and my wife's sitting here, just to give clarity to the background of the application, because I'm conscious that many of you may not have been into our restaurant, so you wouldn't know what we are and what we do, why we're making the application, why we believe the application should be accepted, and also addressing, because we know our neighbours, we're very respectful for our neighbours and their concerns. So maybe so I also wanted to address some of the concerns specifically, to give them the respect that it deserves. Just so going back on the beginning of that, we are a small independent restaurant. We're a small independent fine dining restaurant. We're not a pub, we're not a club, we're not a beer garden, we don't even sell draft beer. We don't have drinks offers, food offers. Our demographic, because a lot of the concerns associated with potential noise, our demographic are 40s to 80-year-olds that are high worth individuals that want to experience a fine dining environment. People book to come to our restaurant. They don't typically walk in. We're table service only. We don't have children, don't have children's menus or meal deals. So fundamentally, our application relates to what we are, which is a fine dining restaurant with a clientele to match. And we're operating well within the council's licensing objectives. And what we're trying to do, we're trying really, really hard to make our dream of owning a restaurant work. And we'll be devastated to have to close it if we can't become profitable. So this dream of ours was never about, and we was misquoted in last time we made an application. So I just want to make sure it's clear. We was never about making profits. Anyone in the hospitality industry, as you know, will know that that's not the industry to go to make profits. All we wanted to do is be a restaurant that delivers a fine dining service, that pays its bills, that pays its hardworking staff, and that was the only objective for our restaurant. So why we're making that application, why we're making it, there's two reasons. Firstly, to increase the sales to balance the books, and the extra time in the garden to allow people to eat and drink will help us balance in the books. We had to use our own money from our own day jobs. We do have day jobs. This is not our job. We have to get up in the morning and go to work. So we've had to use our own money from our own day jobs to pay staff, which is just not sustainable. The second reason we're making this application is we've had situations where customers have been dissatisfied by us exiting them from the premises at 9:30 so we can clear the garden by 10. And it's totally heartbreaking to see them leave us, walk next door into the White Lion, which is closer in proximity to our neighbours' properties than we are, and continue. So it's a bit heartbreaking that, and we are struggling with customer dissatisfaction in that space. Why we believe the committee should grant us this application, we've got a license for serving food and drink in the garden for over a year now, and we've had no complaints from our neighbours. absolutely no complaints. We're respectful to our neighbours, and we are very responsible. I note the conditions in the licence law around responsible owners. We are responsible licensees. We do recognise that the council's vision is to ensure that North Herts continues with offering a diverse range of well-managed licence and entertainment venues, which I believe we are, and a safe and enjoyable environment for a daytime and a nighttime economy. So we recognise that. We recognise also that the council are committed to continue to promote the diverse cultural community activities within the district, providing safe and sustainable nighttime economy for residents and visitors alike. We believe we are doing that well within the licensing objectives. In order to make a balanced decision, I do agree that the council and the state accepts that those living in town centres environments are likely to experience a larger degree of disturbance with a vibrant nighttime economy, and the council will take into consideration the wider benefits of that community. We believe that the wider benefits of the community wants Shea Burton to offer them the ability to eat in our garden later. And within the Licensing Act, we do recognise that the council supports responsible premises owners and fully believe that Shea Burton is a fully responsible licensed premises. We recognise also the council's licensing hours shouldn't inhibit the development of a thriving and safe environment and a nighttime economy. Important for local investment and employment. We employ 15 staff, many of them young local kids that have got their first job that we train in hospitality, and we see them grow up and go to university. It would be devastating for us to have to close our business and lose them their jobs. So they're the fundamental reasons why we would like our application to be approved. There's some specific concerns that I'd like to talk to, just so it's clear, but that we're not overlooking them and that we recognise them, because we do recognise the concerns that neighbours have. Paul Watts, he's mentioned that, and it's because it's in public view now, I kind of wanted to address it. He said now the request is to open until 12 midnight, 6 days a week, and 22:30 on a Sunday. That is not what we're doing. That is incorrect. We're open 4 evenings a week, Wednesdays through Saturdays, and the garden is only open weather permitting, Fridays and Saturday lunchtimes. The garden's probably used only a couple of times, a couple of months of the year, and we've got no plans to change that. So regardless of the licensing, the license, we have no plans to change our opening dates. David and Stephanie Taylor talk about talking in the garden area and playing music until midnight. I don't know why that was in capitals, maybe shouting. This would result in significant harmful noise intrusion. I do not consider people eating harmful. Eating and talking as harmful. I note Maria Free's comments that she has to be up at 6 a.m. And who totally object because it would seriously affect my life and value of my property. We get up at 6 a.m. as well, so we fully understand the challenge of getting up early. And remember, we are only open 4 nights a week. Wednesdays and Thursdays are really insignificant in terms of guest footfall. Fridays and Saturdays are our busiest times. So the impact of Fridays and Saturdays later in the garden would only impact people if they're working on a Sunday, Saturday or Sundays. We close the kitchen at 9:30 for mains. We close the kitchen at 10:30 for desserts. So that's well within the licensing objectives. I can't comment on the property price impact of our restaurant. I don't think the licensing committee can either. There was also mention there that there was attached some photos of my garden to the left of the wall. I didn't see any photos in the briefing pack, so that's, again, should they have been there? Should I have seen those? I don't know. One thing we did take seriously Maria also mentions that I have grandchildren that stay over. If you're drinking till 12 p.m, I would no longer be in a position to let them stay. We're parents ourselves, and we treat this representation seriously. I cannot understand why our application would prevent a child staying from their grandparents. I just really can't. A last one from Karen and Robin Watts. They've mentioned around have to put up with Shea Burton Garden, which can get quite noisy. We totally disagree with this statement. Our garden is people talking and eating. It's really nothing more than that. They also point out looking out over Shea Burton Garden is not a pleasant experience. I don't know what that is, with people gawping at us whilst we're going about our daily lives. We purposely walled our garden with the highest fences available so that no one could look into neighbouring houses. This was brought up when we first applied for the garden licence. The only residential windows on show from our garden are the top floor windows that look down onto the garden as opposed to looking up. So we can't do anything about that. There is another good point, actually. Sometimes the garden lights are left on for several days at a time, which is rather annoying. This is not something that we were aware of until we saw this. Our garden lighting is soft lighting. It's not harsh, it's not bright, but we weren't aware of this. So we'll make sure that turning the garden lights off are part of the shutdown procedures going forward, and we'll adhere to that. So I guess in summary, what we're trying to say here is we've increased the business in the community by attracting guests from far-reaching areas of Bedford, Hitchin, Herts, Bunts. A lot of these people didn't know Baldock existed and what it had to offer. And we're trying very, very hard to keep our dream alive, although fully respect the views of our neighbours. So we do ask that the committee grant the application to allow us to continue to deliver our experience to Baldock and its surrounding areas. And again, to reiterate, well within the licensing objectives set out by the council. That was my only position.
Thank you, Mr. Burton. That's helpful. Right. Do any of the other persons have any points of clarification here for the applicant, Mr. Burton? Mr. Taylor, do you have any points of here's points of clarification?
Not really. I hear what he says. I agree with some of what he says, but I disagree profoundly with the volume of noise aspect.
Well, that's fine. Obviously,
Yes.
you'll be
Okay.
able to make your point in relation to that. This is obviously if you've got any specific points of clarification, but obviously you'll have your opportunity to make that exact representation, no doubt, in a few minutes.
Okay.
No, that's fine. Members, do you have any points of clarification for the applicant? Councillor Dennis or Councillor Allen? Can I'll ask you a question, Mr. Burton? So, am I right in thinking that whilst obviously you say that you're open, that your intention is only to open 4 evenings a week, that potentially the license application here would give you the opportunity to open more often than that? Is that correct?
We have certainly the licensing dates, the days and the times were kind of inherited by us from the previous restaurant. So it was we certainly have no plans to open any other days of the week.
So you open the 4 days that you mentioned, specifically the chill bar, which, am I correct, that's the outside area?
That's the name of the garden.
That's it. So how often would you open that? I mean, I appreciate you talked about weather permitting, but how often would you normally open that during the course of either the summer, winter, and through the year?
I guess it's opening if it's weather like this. It's open when we're open.
Yeah.
So Wednesday we only advertise it. We only serve food out there on Fridays and Saturdays daytime. and the doors open. Yeah. But just as Jackie just clarified, we are open those days. There are certain events, like if a Valentine's Day falls on a Tuesday, for example, we would want to open then, or a New Year's Eve. But going back to the clarification of those opening dates, we have no plans to change those.
On your website, and it'd be helpful just to sort of to clarify at this point. Obviously, you've talked about obviously what you need to do in terms of exiting customers at 9:30 for those who are sitting sort of outside. When I looked at your website before the hearing, it talks about the chill bar being open from, is it sort of midday till late? Obviously also talks about the restaurant also being open from that same time. That feels slightly confusing when you're using that terminology late for both of them, but actually clearly operating a different time. Yeah. It just gave me a slight cause for concern when I looked at the website, as and I understand what you're saying that you're doing in practice, and I have no evidence or any belief that you're doing anything other than that. But it does feel slightly contradictory when you say late rather than open till 10 o'clock or
it's an interesting because we kind of thought it would simplify things rather than giving very specific times for every specific day. And also what it does do, and again I echo that we work for a living. We've got other jobs to do. Saying it opens late allows us to close early. So if we say we're open late and there's no one in the restaurant and we close up at 9 and go home, I don't want somebody knocking on the door at 10 o'clock saying, your website says you're open, why can't I have a dinner? So we kind of used that terminology to probably to cater for that scenario rather than anything else. Okay,
thank you. No, that's helpful. I can't see anything else from members here. So if then I could turn to the other persons to represent their submission supporting the application, and Mr. Taylor, over to you.
Hello there, pleased to be here. I'm a little bit surprised at the fact that, as you say, that Mr. Burton is only talking about having the restaurant open a few nights or a few days, because the fact is that the license will apply to anybody forever for 6 nights and the Sunday as well. So it's a bit disingenuous. At the previous meeting, we thought we had an agreement that was gifted to us for a 10 o'clock closing. We now find that Mr. Burton now wants to change that. It's our naivety, I think, that we didn't complain about the noise that has been occurring, but we're prepared to tolerate that on the basis that it finishes at 10 o'clock. But now we find we're in a position that it's going to go on till midnight. I fully agree with my brother's comments, and as I'm restricted to only commenting on other people's, like Paul Watts and my brother David and Stephanie Taylor, there are a number of properties round, as my brother has said, a total of 7 in fact. I own 2 more next to it, and our windows totally look out over the garden, and Mr. Burton is a bit easy with his comments about the windows don't really look over. They're only 3 to 4 meters away from the boundary where Mr. Burton's garden restaurant is. And on days like today, it's impossible not to have your windows open, especially in the evenings. And the noise is not confined within the boundaries of the garden. The noise just spreads out continually. There are people that live there and wish to go to bed at a reasonable hour of night, but they can't always do that, and they will not be able to do that if this license is granted till midnight. And the fact is that they are living there, it's their homes, They expect some peace and quiet. And they're not going to be able to get this on at least 4 nights of sunny, dry, warm weather, as Mr. Burton has pointed out. And it's not really fair. People will come and dine, and within an hour or two, they'll move on. But the people living there are continually listening to this noise. It's not, I say, an unpleasant noise of people screaming and shouting and making sort of lots of difficult noises. It's just a continual background noise of people eating, talking, laughing and joking. I do have a recording that I took on last Friday. The North Wales District Council does allow people who wish to make noise complaints to use their app to record such things. May I be allowed to play this?
Let me see advice from the licensing officer. I think probably not, but would either the licensing officer or the legal advisor help me on this one?
Yes, Chair, if I can assist. I don't believe Mr. Taylor can put forward this evidence at the hearing. It should have been submitted in advance, and also, although the council does have noise apps, it also means that the council itself hasn't had an opportunity to consider it at all. So at this stage, unfortunately, the correct procedure has not been followed.
Thank you. Thank you for that. I'm sorry, Mr. Taylor, that we won't be able to take that, but obviously we've heard the point that you were making in relation to that. But if you want to continue.
Well, it's difficult to know if I'm not allowed to demonstrate the volume of noise that is there. I can talk about it, but it's not as practical as actually hearing it. But it is very significant. And it does impact on the lives of the people that live there, and that the whole of the garden area, the restaurant garden area, is surrounded by properties, and 7 of them have complained. That's quite a significant number. I would have complained as well had I not missed the boat over the time factor, but there we are. So, you know, some people there do have children, and they're reluctant to have their children come and stay because they want to get them to go to bed early, and there is a considerable noise.
Okay, thank you, Mr. Taylor. Mr. Burton, do you have any points of clarification for Mr. Taylor?
No, not really. I fully respect Paul and his brother's concerns. I don't agree with them. You know, statements of fact. Paul, you just said 7 people complained.
Yeah.
You know, I've got 5 other persons.
We're getting into obviously your response, and you'll get an opportunity to respond. If you've got any specific points of clarification for Mr. Taylor, now you will get your closing comments.
Okay.
In a few minutes. Thank you. Thank you. If not, members, have you got any points of clarification for Mr. Taylor? No, can't see. Can't see anything. So no, thank you for Mr. Taylor, for your representation, and obviously representing other complainants. That's very much appreciated.
Well, I would say I've been a bit restricted because of the format of the committee.
I hear what you say. Yeah, but
I'm not particularly pleased with that. But there we are.
Yeah, thank you. Which then I think takes us into the closing statements of this part of the hearing. Does the licensing officer have any final submissions that you want to make to the committee? You're on mute.
Yeah, it's all right. Yeah, it's a bit slow coming off. Thank you. I just have a brief closing statement. Thank you, Chairman. There is a right of appeal against the subcommittee's decision for any party to today's hearing. That appeal will be heard by, that appeal will be heard by the local magistrates courts, for which the area is Stevenage. An appeal stating the grounds on which the decision being appealed and accompanied by the appropriate court fee must be lodged with the clerk to the magistrates no later than 21 days after the receipt of the written decision notice. At any stage after the grant of a licence, a responsible authority or other persons may request the licensing authority to review the licence if they believe one or more of the licensing objectives are not met. The review is by way of application served on the licensing authority, the licence holder and the responsible authorities, which can be found on the council's website. If the grounds for review are deemed valid, there will be a 28-day consultation period, which representations can be made, similar to the recent application process. A hearing similar to today will be held when the subcommittee would have a number of options, including taking no action, amending timings, activities, suspending the licence or revoking the licence. Thank you.
Thank you. Thank you. Thank you for that. Do the other person, Mr. Taylor, do you have any final submission you wish to make to the committee, Mr. Taylor?
I just repeat that there is a great problem of noise. It's the number of people, 26, 30 people dining, causing a lot of chatter. It does emanate from the garden into the homes of the people that live around there. As my brother has said, there are at least 7 residential properties there. And it's all very distressing for them to think that they're going to have a midnight session. There is the light pollution. If it gets onto a later night, the amount of light that is displayed there, although it's soft, will become more relevant as it gets darker. So it's purely the noise aspect that will emanate from the large volume of people that dine in the garden area.
Thank you, Mr. Taylor. And then finally, the applicant, and Mr. Burton, do you have any final submission you wish to make to the subcommittee, Mr. Burton?
Nothing I haven't said already, really. I would just echo what I've said before. We are responsible and respectful licensees. If any of our neighbours have a problem with it, they can just pick the phone up and we can talk about it, and providing it doesn't detract from the quality of service we give, we'll be amenable to it. We're just really keen to have our business continue, and thanks for your consideration on this.
Thank you, Mr. Burton. And then if I could, I'll invite the legal advisor to summarise, if you wish, any legal issues that have been raised at the hearing.
Thank you, Chair. The subcommittee has heard representations from 7 persons, some of these from the same household, so I think 5 separate households. The nature of the representations received on the form of concerns over noise disturbance and pollution. These representations would fall to be considered under the public nuisance limb of the licensing objectives. Public nuisance is not narrowly defined in the context of the licensing legislative framework, and it will be for the subcommittee to consider whether the relevant concerns evidence that to vary the hours would go against the objective of preventing public nuisance. I also note that light pollution was raised orally by Mr. Taylor at the hearing, and the subcommittee may also wish to consider the condition offered by Mr. Burton that he would ensure that all lighting in the garden area would be turned off and wouldn't be left off overnight. As well as consideration of the key licensing objectives. In particular, the subcommittee may wish to consider Mr. Burton's representation, particularly his reliance on paragraph 1.5 of the guide to the Licensing Act 2003, and in particular about the role of responsible businesses that they play in our local communities, and encouraging and supporting responsible businesses, and in considering whether or not the applicant and Chesburton is a responsible business, the subcommittee will take account that there have been no representations received by the relevant other responsible authorities, and also although Mr. Taylor sought to raise some other matters, there is no evidence of any formal complaints being received regarding nuisance other than through the representations received today.
Thank you. Thank you for that. I'd now like to invite the committee member scrutiny officer to explain the next part of the process.
Thank you, Chair. The subcommittee will now be retiring to make a decision in private. Public viewing the meeting are welcome to wait to listen to the decision. However, this may take some time. Once the subcommittee have made its decision, this will be announced via the live stream. If members believe that the decision will take too long to avoid parties waiting, they may decide not to announce the decision live today. If this is the case, an announcement will be made to this effect by the subcommittee and the meeting will be closed. The decision would then be announced in writing within 5 working days of the meeting. Members and officers will shortly be receiving an invitation to a breakout room. The applicants may stay or leave if they wish. A hold notice will be displayed in the Zoom call and the live stream will continue. Please note that as this is live stream is ongoing, anything said during this time would be recorded. Subcommittee members will now be moving. Thank you very much.
Thank you.
Good afternoon and welcome back to the licensing subcommittee. We are just going to do a quick roll call to ensure that everyone is here. I'm going to start with the panel. Councillor Elizabeth Dennis.
Yes, I'm here.
Councillor Daniel Allen.
Yes, I'm here.
Councillor Ian Albert.
Yes.
And Councillor Raj Bakar.
Hello.
Thank you very much. And for our officers, Melanie Gillespie.
I'm here.
Samal.
I'm here.
Jasmine, are you here today?
Yep, here.
Lovely. James Lovegrove.
Yeah, yeah.
Okay, and our other persons, Paul Taylor, are you online? Okay. Maybe give him another minute. I'll just check. Neil Burton, are you online?
Yeah, still here.
Okay.
Yes,
thank you
I'm
very much.
here. Sorry.
Thank you very much, Mr. Taylor. Okay, we'll
Takes a
pass
while
over.
to unmute.
That's right. We'll pass over to the chair for the rest. Thank you.
Cheers. Thank you. Thank you. Good. It's good afternoon now, everyone. Good afternoon, everyone. I'm going to read you the decision notice from this meeting of the North Herts District Council licensing panel, dated here in 16th of June. Members of the panel, myself, Councillor Albert, councillors also with Councillor Allen, Councillor Dennis, reserve member Councillor Bakar, from the applicant, Neil Burton of Shea Burton, 48 High Street, Baldock, and the date of the application was the 3rd of April. This is an application for variation of a premises licence under Section 34 of the Licensing Act. Subcommittee has read the material presented to it and has listened to all the evidence and submissions. The subcommittee has considered the national guidance and the statement of licensing policy and has come to the following decision. The application is approved subject to the hours as are set out below. The opening hours, the permitted opening hours for both the garden area and the main restaurant will be from Monday to Saturday, that's 10:00 hours to 00:00 midnight the following morning, from Monday to Saturday. Sunday's opening hours will be 12:00 to 23:30. These hours are to apply each day of the year. The licensable activities applied for are Part F, recorded music, Part I, late night refreshment, Part J, supply of alcohol. The hours during which the licensable activities may take place in both the garden area and the main restaurant are Part F, recorded music, that is 10:00 hours to 00:00 midnight hours the following morning from Monday to Saturday, and on Sunday 12:00 to 23:30 hours. On Part I, late night refreshment, the opening hours are 10:00 to 00:00 midnight the following morning from Monday to Saturday, and on Sunday 12:00 to 23:30. Part J, supply of alcohol, from Monday to Saturday, 10:00 to 00:00 midnight hours the following morning, and on Sunday 12:00 hours to 23:30 hours. The subcommittee recognises that the conditions will only be imposed on a licence where conditions are appropriate for the promotion of one of the 4 licensing objectives. The subcommittee will only impose conditions on a licence where relevant representations have been made, and it considers that it is appropriate to impose conditions as a result of these representations. The subcommittee considers that on the admissible evidence received, no conditions are appropriate for the promotion of the licensing objectives. Conditions proposed by the responsible authorities, not applicable. Conditions proposed by applicant. The subcommittee considers that on the admissible evidence received, no conditions are required from the applicant for the promotion of the licensing objectives. Effect of failure to comply with conditions explained to applicant. The effect of failure to comply with any of the conditions attached to the license or certificate is a criminal offence which upon conviction would result in an unlimited fine or up to 6 months imprisonment or both. Statutory guidance considerations. The subcommittee has taken into account the guidance issued under Section 182 of the Licensing Act 2003, the April 2018 version, in reaching its decision. It's found a number of sections to be of particular relevance. I will not read them all out, but they will be in the formal decision notice. On licensing policy considerations, the subcommittee has taken into account the North Hertfordshire District Council's statement of licensing policy in reaching its decision. Again, it's found a number of sections to be of particular relevance. Again, the full list will be in the decision. Rationale for decision. The subcommittee considers that the variation application should be permitted to the extent outlined above for the following reasons. Subcommittee has received no evidence from the police, environmental health, or any other responsible persons to suggest that the premises have not been run in accordance with the conditions of its existing licence, and has seen no evidence that any concerns have been raised by other third parties to any of the responsible persons regarding the premises prior to the representations received as part of this variation application. In the circumstances, the subcommittee considers that on the evidence, the applicant is running responsible premises and notes the principal aim under paragraph 1.5 of the 2018 licensing guidance to support responsible premises. And 2, the concerns raised by third parties have been in the nature of alleged public nuisance. However, other than the bare assertion, the subcommittee has received insufficient supporting evidence to suggest that any noise generated from the premises would amount to a public nuisance. 3, the applicant has sought extended hours on special days such as Christmas and New Year's Eve, but has failed to provide sufficient information as to the extended hours sought, and as a result, the subcommittee has been unable to determine the appropriateness of the exceptions to the operating hours having regard to the licensing objectives. 4, the subcommittee considers that the application to play recorded music in the garden area from 1000 hours on Sundays to be a typographical error, as the opening hours of the premises is stated to be from 1200 hours on Sundays, and it notes that the hours of 1200 is consistent with other licensable activities. Commencement date. This license will come into effect from the date of this decision. Rights of review. At any stage following the grant of a premises license, a responsible authority, such as the police or any other person likely to be affected by the premises, may ask the licensing authority to review the license because of a matter arising at the premises in connection with any of the 4 licensing objectives. The review is a request for the council to look at the existing license and decide whether its conditions are adequate to meet the 4 licensing objectives defined under the Licensing Act 2003. That concludes our decision. I'd like to thank all those here today. I absolutely appreciate that the decision will be welcomed by some and obviously not less welcome by others. I do understand that. I would remind, obviously, the other persons that clearly there is their continuing right of review to the license, and that obviously you raise some other issues which can be picked up with North Herts Council officers in response to any of those particular concerns that you wish to raise, and obviously to remind the applicant that clearly in terms of the other special dates there is the TENS application process that you can follow. Again, as I say, I'd like to thank all member colleagues there, legal and licensing team, obviously especially the applicant and indeed Mr. Taylor on behalf of the residents, the other persons today. Thank you all for your time, and I wish you a very good afternoon. Thank you, colleagues.
Thank you.
Thank you.
Thank you, Chair.
Thank you, Chair.
Thank you.